we operate. Obviously, when we start, what I need for you to do is tell me your name, and then you can just tell me whatever you want to, or tell us, I'm sorry, about what you're here today for, what your appeal is all about. Do you have any questions about anything before we start?
No, sir. I try to watch the oral arguments prior to coming, so I was trying to brief myself prior to arriving.
Sure, and I appreciate that very much. You understand that this is being live streamed, okay? So what you say is being recorded. It'll be on the internet. You understand all that?
Yes, sir. I
Okay.
realize that.
All right. Well, if you don't have any questions, then we'll be ready to hear from you. If you'll watch the lights, when you start your argument, your green light will come on, and then it'll rotate through. You'll get a yellow light when you're about to run out of time, and a red light when you're out of time. If you finish before, that's fine too. You handle it however you want to, okay?
Thank you, sir. Well, I was going to reserve 3 minutes for rebuttal. I thought I seen Mr. Lewis. I don't know.
Well, he's not in here.
Okay.
And I think he's waived his oral argument, I believe.
I don't think he was going to be here, so.
Okay, so unless he shows up, and he's not here right now, then there's no need for rebuttal time.
Perfect. So my name is Cassandra McGuire.
What, just a second. You ready?
Yeah.
Okay.
My name is Cassandra, Cassandra McGuire. I am the mother of Drake Lewis, and I have about 2 years criminal justice. 1 year before I complete paralegal, so I'm limited in law understanding. However, I've done a lot of research. With that being said, again, before I get started, may I please the court? I stand before you today as someone who has been denied justice for over a decade. Not because I failed to follow the law, but because the very system meant to uphold it has knowingly disregarded its own rules. My case is not just about child support or custody. It is about fraud upon the court, judicial overreach, and the blatant enforcement of void orders. Despite the Tennessee Court of Appeals 2010 rulings, which voided the child support obligation and ordered a recalculation, multiple judges have acted without jurisdiction, enforcing an illegal debt while systematically depriving me of my parental rights. This is basic justice. In 2007, an invalid temporary restraining order was improperly used to change custody without merit, bypassing the legal requirements for an emergency hearing to determine whether material change in circumstances warranted modification. Tennessee Rule of Civil Procedure 6504 mandates that TRO is issued only upon specific findings of immediate and irreparable harm, supported by clear evidence. Yet in my case, the TRO is granted without a hearing, without statutory findings of harm, and without affording me the opportunity to contest the allegations before custody was unlawfully altered. Instead of holding a required emergency hearing, the court treated the TRO as a de facto custody order, ultimately leading to a permanent modification without due process, violating Tennessee Code 366101, which requires court to evaluate custody based on the child's best interests and material changes in circumstances. The improper reliance on invalid TRO rendered the entire custody modification process void, as the court failed to make any statutory findings supporting the custody change or to conduct a relocation hearing as required under Tennessee Code 36108, violating procedural due process. The Tennessee Court of Appeals 2010 ruling explicitly voided my child support obligation and ordered a recalculation based on verified financial records. Yet Magistrate Judge Ellen Kern, ADA Stephen Powers, Judge Jackson, Mize, Monsu, and Attorney Abin Rubenfeld all ignored this appellate mandate and continued to enforce the void $3,033 income figure without proper verification. Magistrate Kern, who was never formally appointed to oversee or modify the appellate ruling, treated the modification case as a child support only matter, disregarding custody and statutory independencies, despite lacking jurisdictional authority. ADA Stephen Powers, acting outside of his statutory role, enforced void child support orders and further contributed to the unlawful financial penalties and enforcement measures imposed against me. Attorney Abin Rubenfeld knowingly misrepresented the appellate court rulings by falsely asserting that the $3,033 child support obligation had been upheld, despite the 2010 mandate required recalculation. Their actions violated well-established legal precedents, stating the judicial actions taken without jurisdiction are unenforceable. State v. King, Tennessee, 1998. Denton versus Woods, Tennessee Court of Appeals, 1999, and the continued enforcement of void orders nullifies all subsequent legal actions derived from it. Brown versus Brown, Tennessee, 1955. The trial court improperly treated a temporary child support order as permanent without conducting final hearings. Tennessee support orders are meant to be provisional, yet have been subjected to their enforcement for over a decade without due process. The trial court improperly applied Tennessee Code 365101 by treating my case as a child support only matter, disregarding its direct connection to custody and visitation rights. This misapplication of law resulted in unlawful enforcement actions against me despite the Tennessee Court of Appeals 2010 ruling voiding my child support obligation and ordering a recalculation based on financial records. Extrinsic fraud upon a court occurs when judicial officers deliberately misrepresent facts, obstruct justice, and violate due process protections to achieve an unlawful outcome. In Hazel Atlas Glass Company versus Hartford Empire Company, the U.S. Supreme Court held that fraudulent misrepresentations by officers of the court fundamentally undermine judicial integrity and render resulting judgments void. In my case, court officials, including Jackson, Kern, and ADA Stephen Powers, knowingly misrepresented the Tennessee Court of Appeals 2010 directive, falsely claiming that my child support obligation of $3,033 was upheld as far as income, was upheld rather than voided. This misrepresentation directly contradicts the appellate ruling, which explicitly mandated a recalculation based on verified financial records. Their intent to deceive is evident in their failure to verify financial records as required by Tennessee Code 36501E, their continued enforcement of legally non-existent obligation, and their strategic use of fraudulent enforcement actions to inflict financial and legal hardship upon me. The enforcement of void child support orders extended beyond state lines, utilizing federal wage garnishment and tax intercept mechanisms in direct violation of the Commerce Clause and the precedent established in Bailey versus Bailey, which requires federal compliance in interstate child support enforcement. The use of coercive legal threats, financial extortion, and wrongful incarceration threats based on void obligation constitute extortion under the Hobbs Act, as these officials leverage their judicial authority to extract money from me under fraudulent pretenses. Additionally, by knowingly disregarding the due process protections, obstructing justice, and enforcing orders without jurisdiction, these judicial officers engaged in actions tantamount to treason under 18 U.S.C. 2381, which criminalizes the betrayal of constitutional duties by those in position of public trust. Judge Monsu exceeded his jurisdictional authority by continuing to enforce over support obligations beyond the legally permissible time frame, despite my child reaching 23 years of age. Temporary orders are reserved for temporary matters and cannot serve as the basis for indefinite enforcement without proper adjudication and conversion into a final order. Rigsby versus Rigsby, the Tennessee Court of Appeals emphasized that temporary child support orders must be finalized through statutory proceedings before they can be enforced long-term. Similarly, Tennessee Code 366404 requires that modifications to custody and support be incorporated into permanent parenting plans, ensuring due process and compliance with statutory requirements. Despite these legal mandates, Judge Monsu improperly treated a temporary support order as permanent, disregarding the Tennessee Court of Appeals 2010 directive that voided my child support obligation and ordered recalculation based on verified financial records. Additionally, he misclassified my case as a child support only matter, ignoring its origins of modification case that inherently included custody and visitation issues. This misclassification permitted the enforcement of void financial obligations while failing to adjudicate ongoing custodial interference, demonstrating judicial bias and procedural misconduct. Furthermore, General Sessions courts lack jurisdiction over domestic relations matter, including child support and custody disputes. During court proceedings, Brian Lewis openly admitted using child support as leverage to block visitation rights. What he stated is that he deliberately left the modification open pending 2012 and that I owed back child support. His admission established a clear intent to interfere with my legally granted custody and visitation rights by conditioning my access to my child on financial obligations. Despite this blatant interference, the courts failed to hold him accountable, instead aiding and abetting his misconduct by refusing to enforce my court-ordered visitation rights while continuing to enforce fraudulent child support. The court's pattern of selective enforcement, ignoring custodial interference while imposing severe financial penalties based on fraudulent child support calculations, amounts to criminal conspiracy that violated my due process rights under the 14th Amendment of the U.S. Constitution. By allowing Mr. Lewis to weaponize child support as a means of parental alienation and by refusing to address repeated legal violations, the court actively facilitated and enabled criminal conduct. This coordinated effort not only deprived me of my parental rights, but also constituted a form of extortion and coercion under Tennessee law, necessitating judicial intervention and immediate corrective action by this court. Lastly, over a decade, I have actively pursued every legal avenue available to rectify this wrongful enforcement of child support and restore my custodial rights. Despite a 2010 ruling from the Tennessee Court of Appeals voiding my child support obligation and requiring recalculation based on verified financial records, the low courts refused to comply, continuing to enforce a fraudulent obligation that was never lawfully determined. My efforts to expose judicial misconduct and fraud upon a court, including reporting violation to state agencies, have been met with systematic obstruction, further exacerbating my legal and financial hardships. Instead of addressing the procedural and jurisdictional violations in my case, the court system has engaged in retaliatory measures, including the wrongful arrest in 2021 in an attempt to silence my claims and prevent me from obtaining the justice I am legally entitled to. These persistent legal injustice underscores the necessity for immediate appellate intervention to correct the fraudulent enforcement of child support, restore my parental rights, and hold accountable those that for violating both state and federal law.
You said restore your parental rights.
Yes, sir.
Were your parental rights removed?
No, sir.
Okay. Just wanted to make sure that I had an understanding.
What I meant by that is my son, he's 23 now, and once I was given authority when he was 17 by Davidson County, I spoke to a sergeant. He said, "Cassandra, you have all authority. They never completed this parenting plan." He reached out to Dickson County detective to try to initiate an investigation. I never heard anything back. So today, as far as when I say restore parental rights, I am obligated to that child. I have to explain to him what happened. So that's why I'm here. You know, he wants the truth. So when I say restore my parental rights, let him know the truth. Mom has fought. Mom has done everything. She hasn't left his side. She didn't terminate these rights. The courts didn't terminate these rights. These patterns did. His dad did not follow through with the modification. The courts did not intervene. Nothing happened. DCS did not intervene. No one intervened. He's 23, and he does not know. So the rest of my life, I get to explain to him, this is what happened. This is how I can make it better. These are my only options to make this child whole again. This is it. You are the final say.
Anything further?
No, sir.
All right. Here's what we're going to do. We're going to take the matter under advisement. We're going to review the record, which is what's been filed here, and we will issue an opinion. Opinion will be mailed to you, well, emailed, mailed, I don't know, however, whichever way you select, but you'll receive a copy of it. We don't announce a decision today, okay?
Yes, sir.
Any questions about any of that?
No, sir. Thank you for your time.
All right, thank you.
Yes,
We
sir.
appreciate it. We will stand in recess to the call of the afternoon docket.